Hello, fellow Toolboxers. Welcome to episode number 360 of the Immigration Lawyers Toolbox podcast. I'm Immigration Lawyer John Kasrabi, coming to you live. I was going to say, but it's not live; it's recorded from Los Angeles. What I'm really happy is I think I got the microphone at the right distance, so that my sound quality doesn't go terrible, like I've been seeing it happen in the last couple episodes. So let me know how sound quality is, and I'm going to listen to it afterwards. But that's something I'm excited about. I'm thinking about. Having said that, today's going to be a top 10 episode. Top 10 things I learned. I don't know how to properly title this because it's not top 10 immigration law updates. Because sometimes it might be something from 15 years ago I learned right now. But just top 10 things I've learned. Now, top 10 things I've learned sounds interesting, but it just gets too long. I don't know. Let me know. Maybe vote on what the best title is. But anyways, we're going to get into that. I'm recording this in December. I took too long to get this out. So I'm going to title it as if it's a November one. And then hopefully in a week or two, I'll do another one of these because I got enough top 10 stuff plus to do it, to talk about immigration law. And there's just things I picked up along the way. Someone's new updates, stuff like that. So it's a very important episode. If you're an immigration lawyer, you should be listening to these because if I'm learning these and I'm obsessively studying stuff all day, there's a chance that you're not going to know a couple of them either. Having said that, we're doing this really cool regular session nowadays where we go over case studies that I've done, and I help share with a small group of practitioners. We're having one on January 16th, Thursday, 10 p.m. a.m. Pacific. It's $250. You have to be a lawyer, and it's about E-2 visa, consular processing, less than $100,000 for a small retail store. We're going to go over the issues we had and go through the filing, all that kind of stuff. Redacted, but we're going to talk about it in a private session. Limited to 8 seats, but we have 3 seats left. When you book it, it says 4 seats, but it's not. It's 3. I'm not sure why it doesn't get updated. So get it now. If not, email me. We're going to have a registration link for like future ones, like a wait list, so you get notifications of that as it comes up. But it's a great session. I enjoy even just doing it myself because it's like, even while I'm talking, I learn from it. And it forces me to, people ask questions and you get better as a practitioner, and you share a lot of information too in a good setting, and you make good friends and colleagues out of it. So we're going to do that one. And if it fills up again like it did last time, which I'm sure it will in the next week or so, then we're going to probably do it more often because this is a lot of good information. People need this, especially people who are going for business-based practices. We eventually get into NIWs, EB1As, O1s, all that kind of stuff as well. L1s, which I'm getting back into. So there's a lot to teach there. Probably going to do a whole L1 course, but these are expensive courses because they're like 20-hour courses or something like that. The marriage green card course out there if you're trying to get into marriage immigration law, which is like the best that you can do and stop going to court. But it's an expensive course, and so 1 out of 5 leads actually purchase it. But hey, it's worth it. It's going to change your career and change your life. You got to make that decision for yourself. So the following information is not intended as individual legal guidance. Please consult with an immigration attorney about your case. This is for immigration lawyers, not for regular people who listen to this, but you all know that already. All right, so top 10. Let's start with number 1. The Department of State does not accept matter of Arabelli and Yarabelli. So there's this idea that if someone, for example, DACA people particularly, enter the United States without admission or parole, and then they get advanced parole to travel and come back, that lawful entry, paroled entry, is enough for adjustment of status. So one thing some people do is they get that parole, and then they have a consular processing case. They do consular processing, and with the hope that it's going to be given the ability to return to the United States with an immigrant visa. However, it's not the case. The Department of State has said, and you can check it out at AILA Doc number 241-02400. Again, that's AILA Doc number 241-02400. That says embassy doesn't accept that. You left at that point, so you're subject to a 3 or 10-year ban, and they're not going to issue an immigrant visa without a waiver. So the idea of Arabelli, it works for adjusting status if it's possible. For example, marriage to a U.S. citizen, if you fix it and have that parole entry or something like that, or TPS entry, I guess, something like that. But it doesn't work for the purposes of consular processing. Speaking of the disaster of consular processing, the National Visa Center issues with uploadings, it's as of December 22nd, is even worse than ever. You get this image error or something like that. They keep saying they're trying to fix it on the Facebook groups. Everyone comes up with a different. It's like when you're sick and someone says, "Oh, I have this old recipe. Get some mayonnaise and dip it in some vinegar and then throw up in the air and then this and that and then it'll cure you." All these different like things. That's everyone's doing this. Oh, go and open up this kind of window and rescan this, and we do all of it. None of it works. Sometimes it works. Sometimes it doesn't. It's a fluke. But it's a real major pain that you can't upload documents properly in the CAC system. Everyone's dealing with it. So we're dealing with this headache too. It adds so much time unnecessarily to our processing. So I'm very sad about that, but it is what it is. Next, number 4 on the tips is Qatar got on ESTA. So the electronic what does the ES to stand for? Electronic something travel authorization. I forgot the S is for. But essentially the visa waiver program. Qatar, the country of Qatar in the Middle East, a little peninsula south of Iran, got on the visa waiver program. I guess they didn't have a lot of overstays, so they could use that program. What does that mean? It means a lot more people from there potentially getting married, do adjustment of status, frankly. That's what that probably means. And overstays and all that kind of stuff. But not that many. It's not a big population in Qatar. I think they have more workers coming into that country than actually live there. I can't say for sure, but I think that's how it works there. But just neat thing that popped up. Number 5. So prostitution is an admissibility issue. I ran into a case where we're going to do a waiver for that. It was interesting. So in the process of trying to figure out what's going on, because I haven't had to deal with prostitution cases before for adjustment of status, I started reading AEO decisions, and there is one line of argument that works. It won't work in our case, but it works, that says if they prostituted, but it was not like a regular thing that they would do, it's not an admissibility issue, and you're not even 212 admissible. So if you do run into a case where someone was a prostitute, they prostituted once or twice, you could argue it wasn't regular and continuous kind of thing. Find that case in AO decisions. I wish I saved the name of it, but for this purpose, I didn't. But hey, that's something that could help your case out and do something with it. Next, number 6 is about P1 visas. The Immigration Lawyers Toolbox magazine is coming out. And one of the articles, I'm going to save probably the February article, but this one, but it's a really in-depth article by Jeannie Doyle, one of the best immigration lawyers in the P space. But I was reading it, I'm like, I didn't realize, like, it's this weird situation. I'm going to read the Foreign Affairs Manual to you, 9FAM 402.14. It says for P visas, now P visas, a lot of times the entertainers and stuff like that. It says a P visa applicant is presumed to be an immigrant until the applicant establishes they're not. So it's 214B. It applies to P, okay? But then it says U.S. residents abroad, the P imposes a residence abroad requirement. Consequently, every P visa applicant must establish that they have a residence abroad with they have no intention of abandoning, which is kind of hard if you're going to be here touring and stuff. Okay, that's it. But then it goes dual intent. I'm like, what? P's are dual intent. What about the previous stuff? It says DHS has determined, so it's not it's not a policy manual for consular processing, I guess, but DHS has determined that the approval of a permanent labor certification or the filing of an immigrant visa petition for a non-citizen is not the basis for denying a P visa or for DHS to deny a request for extension, blah, blah, blah. This non-citizen may legitimately come to U.S. and stay for temporary stay as a P non-immigrant and depart voluntarily at the end of their authorized stay and at the same time lawfully seek to become an LPR in the U.S. However, this dual intent provision does not apply to essential support personnel. So I was kind of weird. It's like dual intent, but it's not dual intent for P's. And so, because, you have it, H1Bs, be careful, it's not all H's, but H1Bs are dual intent, L1s are dual intent, but P's are dual intent, but not fully. They're still subject to 214B. Okay, well, that's that. I mean, it's kind of weird, but I thought I'd share that. I don't do P's myself, so I thought I'd share with people who are getting into that. Number 7. If someone has conditional permanent resident status, CPR, I guess, and it's terminated, we could apply for, what was the notes on this? They could apply for adjustment of status over again once that's terminated, just because the I-751 was terminated, as per matter of Stockwell. It's a BIA decision. So regardless of whether USCIS issued termination of a conditional permanent resident status, if they didn't file it, for example, after 2 years, they could just file a new one. That's a termination by itself, even if it's no I-751 denial notice or something like that by USCIS. But hey, be careful. There's risk removal proceedings involved if you don't file your I-751. But if you file the marriage adjustment again after that, it's probably fixable. But USCIS got to deal with that. And be careful. For example, if you get married, get a conditional permanent resident status, and then don't file removal of conditions because, like, for example, you married someone new, you don't want to even bother doing that. You just want to get readjusted under new status. The expiration of the green card will be a terminated status for the purposes of reapplying for adjustment. But practically speaking, they might look in that first relationship anyways for fraud analysis. So maybe it's better to just do a removal of conditions with a waiver base. So, but that's interesting. As a matter of Stockwell, STOCKWEL is there. I haven't had to deal with that particular scenario before, but it's good to know. Next, number 8, this is an issue that popped up because this guy came to me and analyzed his case. He had several lawyers that messed up and didn't understand it. And this is the marriage green card course. This is what it's all about. Why it's like the best course out there, because we read the statute and learn the law, not just reading cover letters. But under Immigration Nationality Act, Section 245, that's the adjustment base primarily. This is asylum-based adjustment, which is separate, but this is the main adjustment statute, INA 245. There's a section called C, and then within that there's C8. And essentially, this is a scenario. If someone has ever had an immigration violation and they file for a green card, they can't get a green card. They have to do consular processing. There are exceptions to that. For example, married to U.S. citizen or something like that. But the reality is this: sometimes people have a violation, they leave the U.S., they come back in, they think that cleans it up, but it doesn't for certain cases. So it doesn't matter. It cleans it up for marriage adjustment, for example. Even the violation before could have fixed it up. But if you have an employment-based case and the person is able to come back in for that case with admission, not parole, 245K kicks in, so previous violations get erased or not. It depends on what the violation is, but essentially they're not problematic for adjustment. You can still do that. However, it doesn't work, for example, if you're married to a green card holder. So let's say a person overstays an F1 visa, goes back out and comes back in with parole or TPS at readmission or something like that. They already had lawful entry, so that was an issue. The issue was that they did not keep continuous residence, so they had violations by not doing that. So they're not able to adjust if they marry a green card holder. Now, USCIS may still approve the case mistakenly. That happens, but it doesn't mean it's correct. So C8 is very important to be aware of. Previous violations, even 20 years ago, will prevent a person from adjusting unless they fall within the exceptions of a marriage U.S. citizen, potentially employment-based kind of case, 245K, 245I, that kind of stuff. But others don't. Marriage to a green card holder is always something you have to be sensitive about because the protections that you get of being married to a citizen are always there. Sometimes it's best to have the U.S. spouse become a citizen before filing because there's all sorts of protections. Side note, we had another case came to us where they were denied because the U.S. petitioner got the green card originally through marriage, divorced spouse, remarried, and filed for petition. If they had just waited another year and a half and then filed, it could have fixed the situation up because by filing it too soon after, within 5 years of getting the green card, this higher standard comes for proving the marriage is real. That goes on a side topic. This is a tip on its own, but I wouldn't label it as such. But just be aware of that. Number 9, big update in the J1 space. This is really important. The skills list has been updated. So certain countries, if you're coming from the United States to study, you're subject to a 2-year home residency requirement on your J1 visa if you came with a J1 culture exchange visa, which is really harsh because you have to go back to your home country, wait 2 years or country of residence, and then you could come back to get an H-1B and L or potentially a green card or be able to change status in the United States. But they did away with that for tons of countries. They really opened it up on the skills list issue, but you got to be aware. People can get stuck still with the 2-year home residence requirement if you got certain funding. I had a recent case for Germany. They got funding and they were subject to it. Easy to waive, but nonetheless, it's there. Getting waived, it's easy, but it took like 8 months for something that's easy. I have people in these, like this one Australian Facebook group I'm part of, and I mentioned someone has a J. I'm like, be careful, you're not subject to home 2-year home residence requirements. People like bash me, oh, you're trying to lie, this and that. I'm like, no, dude, if you got funding, you're getting hit with it. It doesn't matter what country you're from. Or if they're studying medicine, that's another issue that could pop up as problematic. So things to be knowledgeable there. But hey, the skills list opens it up, thankfully, so people have to deal with this waiver issue much less. And number 10, I'm not sure I go for, I'll just do another top 10 in a week or so I get the, because there's other important stuff I want to get into. But number 10, unfortunately, CDC and stuff is potentially requiring some people, it depends on your doctor, talk with a civil surgeon, but to get a booster shot for COVID, like a 2020 version of the booster shot that's available, which is really annoying. People aren't expecting it. Some doctors are requiring, some are not. I'm not really sure what in the world's going on, but it seems that the COVID booster shot is still needed even now in 2024, going into 2025. I wouldn't want to get it at all. It's a shame. Hopefully that's one of the things RFK Jr., if he has power, could take away. You shouldn't force people to take a booster shot at this point. I mean, come on now. But anyways, do you prepare for that? Your clients might get hit with it, so let them know, because you might have a case where it's smooth and the client then comes up and like, I don't want to get the booster. I'd rather not even adjust. And at that point, you're already done with the case, all that kind of stuff. I mean, the big note on this is, I forgot to mention, is the USCIS updated its regulations, so you have to submit the medical checkup I-693 with the adjustment status application. So that's something you have to deal with at the very beginning of the case. You can't deal with it later. So just be aware of that. It has popped up. We came up in one of our cases. They mentioned, I'm like, what are you talking about? Booster 2024. So I had to just study. When you go to CDC's website to try to figure out what's going on, terrible writing, terrible explanations. Very, very hard to figure out what in the world's going on about this requirement. Very frustrating. But hey, that's U.S. immigration law. I'm immigration lawyer John Kasravi. If you want to join our E2 group and you're a lawyer, email me, info@immigrationlawyerstoolbox.com, and I'll send you a link to the Calendly booking page, info@immigrationlawyerstoolbox.com, and most likely it'll be booked by the time you contact us, but I'll get you on the wait list, so just let me know. We'll get you on there. Thank you so much for joining. If you want more information about our marriage green card course, send me an email. We'll have a quick chat about that, info@immigrationlawyerstoolbox.com. Having said that, God bless, be safe, and I'll see you on the next one. Bye-bye.